kick off. Welcome everyone. My name is Eleri Griffiths. I'm a barrister at One Pump Court Chambers. With me is Daniel Grütters, who is also a barrister at One Pump Court Chambers. We're both members of the housing team, housing and community care team, I should say. Today's seminar or webinar is on homelessness reduction with an emphasis on the personal housing plans and relief duty. Some of what we say obviously will apply to things arising under the prevention duty, but we've focused on the relief duty and the personal housing plan and that aspect of it. The main reason being that between us, we've had a number of cases come through in the last few years with various different trends that we can see, some really good practice in local authorities, some things that we're seeing which have given us cause for concern. And one of the major prompts really for this webinar is to try and see where the consistency is and how people are approaching the challenges, whether that's challenges, indirect challenges to the plans and assessments, how people are doing that, and some of the ideas that we've had, some things which have worked for us and for our clients and we think might be helpful to share. Despite the fact that we're now some 4 years from when the Act was introduced or when the Act came into power, there is still relatively little higher court authority. So it could well be that in the next year or so or next few years, one senior court looks at this and tells everybody how to do it right or wrong. But until that time, we're left in the county court with some county court decisions. Daniel's going to take us through some of those challenges. And we're going to look at some of the strategies that we can deploy in the meantime to try and get the best results for our clients. So if we go on to the next slide then, Daniel. So there's 5 things we're going to look at today. Starting at the top, some of the legal principles, just a refresher. We're very mindful that people attending this webinar will have gone through a lot of these cases already. So we're not really going to go too much over old ground, but we're going to start with the foundations because that's really where we're building our arguments from in the challenges that we're bringing. We'll then look at why getting the assessment right is important. Daniel will take through some of the challenges to the assessments and some different ways of challenging the reasonable steps. And then I will deal with interim accommodation and with some issues of delay, which we have seen come through. So if we jump into it then, just for you to be aware before we start, obviously there is a chat function. There is, I think, a Q&A or a raise hand. At the end, we'll try and deal with some questions. Hopefully, we'll cover most of what you need to know in the seminar. But of course, if there is something that you want to ask, then do pop it in the Q&A and we'll do our best to ask it. We're aiming for about an hour, not to take too much out of your afternoon, but we think that we'll be able to get through all or most of it in that time. So starting then with the assessments, we know that the trigger is somebody who the local authority is satisfied is homeless or and eligible for assistance. And we know that the duty to make an assessment is a mandatory one. So it's not a discretion, it has to be done. There's been relatively little controversy we have found in local authorities actually agreeing to do it at all. Where there is somewhat more controversy is in how they do it and what approach is being taken. And the Act is pretty clear on some of the things which have to be considered, which include the circumstances which caused the applicant to become homeless in the first place, what their housing needs are, including in particular what accommodation would be suitable for them and what support would be necessary for them to be able to retain suitable accommodation. Emphasis there on retain. Sometimes what we see is local authorities doing quite a basic assessment which only looks at how to get an applicant accommodation, but doesn't at all deal with how they might retain it. And this is really an important part of the assessment because fundamentally what the assessment is intended to do is to look at what went wrong before, what led to an applicant being homeless, and how to deal with or how to stop that from happening again. And that requires looking at the root cause of what the homelessness was and how to deal with that. And then through that, then applicants should be in a better position to be able to retain accommodation going forward. In relation to the notification requirements, simply doing the assessment isn't enough. They have to notify the applicant of it. And again, that's really important, because that assessment, as Daniel will come on to, is actually a really important part of the whole homelessness structure. So it's really important that applicants know what's gone in it, what's missing from it, and how that can then, that can be dealt with in a challenge. Next slide. So 2 options a local authority has. One is to try and agree steps with an applicant. The second is to, if they can't agree steps, then they need to explain why and any steps that the authority thinks an applicant should be doing. I myself have seen actually a few issues really in relation to the second option, mainly because I haven't really seen many cases where there has been a disagreement. And I think fundamentally that is due to a power imbalance, and applicants going along to a local authority, and then they'll simply be told, this is what it is, do you agree? And applicants often just agreeing. And I think that is the case, certainly in the cases that I have seen pass across my desk. It's mainly if there's a deficiency in the application, it's one that an applicant has agreed to, because they simply don't know often what, that they have that option to disagree with the authority. Looking then at what can be included, they can include advice. They don't have to include advice in the application, but often you will see on the assessment form, it's usually the same form across a lot of local authorities, and you will see some basic advice often just put in there. Whether that's tailored and whether that's appropriate for an individual applicant remains to be seen, but often there will be something in there, something basic about being able to get alternative accommodation. Again, the authority has to give an applicant a copy of any written record that they have of the agreement. And again, that's really where we find the deficiencies. If we don't know what it is that an authority has decided, then, or what's been agreed, then challenging it can become obviously very difficult. So really important, I think, that applicants are aware that they have to be given notification of what these decisions are, and that has to be done in a timely manner, which I will come to at the end of this session. So do you want to move along to the next slide? Then we've got the review obligation. The really important thing to note here is about keeping it under review until the authority considers that they don't owe the applicant any duty under that act. So it's not just something until somebody gets accommodation. It also it gets a main housing duty, for example. It also has to apply throughout the performance of that. And that's really important when we're looking at suitability of accommodation and what somebody's assessed needs have been. The obligation to keep under review applies both to the assessment of the applicant's case and the agreement which have been reached. And again, that's important. It's not simply the agreement, but actually this obligation to keep under review stems right the way back to the original assessment. There isn't anything in the Act or the Code which says that there has to be a change of circumstances or anything at all to trigger a review. And in fact, as I'll show in just a moment, the Code of Guidance actually suggests the opposite, that it should just be happening as a matter of course. So where there is something which perhaps has been missed in the original assessment or some new information which has come to light, then I think local authorities do need to be urged that, you know, this may or may not change the steps, but in any event, it is something, it is different, which needs to be looked at in the assessment itself, because even if it doesn't change the steps they're going to take, it might be something which affects what accommodation would be suitable for them in the long term. So I would emphasise, it doesn't have to be a sort of material change of circumstances, doesn't have to be sort of just simply new material. It can just be that you have to do a review of the case because whatever steps that you've done or whatever assessment you've carried out, you know, we're 3 weeks into the relief duty, this person's still homeless, there's still nothing which appears to be happening, there doesn't seem to be anything, any progress being made. You need to review what assessment you've made, whether actually you're going to be able to meet this person's needs or the steps are going to meet these needs, and whether there needs to be a change to the steps. So Daniel, if we just go on to the next slide. And then on this slide, then we've just, again, reminding ourselves that there is still a notification requirement. So it shouldn't be that an authority behind closed doors is reviewing their assessment and changing the steps and those sorts of behaviours. Any sort of change, to the assessment or to the plan needs to be notified to the applicant. That could, of course, mean that they leave it at the authority's office. But again, they should still be telling applicants that that's what they've done so that they can at least pick it up. Next slide. So just looking at what the Code of Guidance says, the Act itself is fairly basic. It has some prescribed requirements, but really there's a lot of help that we can find in the code, which deals with the substance and the rationale behind this. And I think we have to remember that this Homelessness Reduction Act was an act which was brought into effect to catch those people who fell through the net. So before the 2017 Act came into force, we had people who were owed the main housing duty, and we had people who were not, and really those people just sort of got very little help at all. So I think it's important to remember that this Act and the purposes of these initial duties and changing these duties was in order to catch these people in the middle. And the first thing to remember is it is supposed to be a team effort. It's not supposed to be a local authority simply giving applicants a list of things to do and sitting back and doing very little else once the applicant has left the door. And I'm afraid that is probably the biggest fault that I see when you have a personal housing plan and an assessment which says, the steps that the local authority will take constitute providing you with advice about landlords in the area, and we'll do that by giving you this sheet that you can take with you today. And secondly, we'll give you information about the local housing allowance, and the rest is up to you. And the deadline for us to do our things is tomorrow, and the rest then you can get on and do and let us know, how you get on. And that isn't the approach which is supported by the code. It talks about a positive, collaborative approach. It talks about tailoring it. It talks about interviews, in most cases face-to-face. And in my experience, the best personal housing plans have been ones which have been done face-to-face, or where there's been adjustments if they've been necessary. But oftentimes, applicants are not really able to engage if there's simply a phone call which takes place relatively quickly, just saying what sort of accommodation do you want, just a few minutes, perhaps 5 or 10 minutes, and then that's the end of it. Where an applicant actually goes down to see a housing officer, in my experience, certainly, they have come out with better personal housing plans, and applicants have felt more involved. So I think that's just something to look out for, is how is the assessment actually being carried out, and is that consistent with the code? And the last point on there, 11.9, that could become really important when we're looking at assessments where perhaps an applicant hasn't been forthcoming about information. And it might be that that information becomes relevant later in the process. And an example I can think of is where an applicant, for example, may say that they are homeless because they're sort of fleeing violence or something. And later on, when that's explored, or they might say initially that there's a relationship breakdown, then when it's explored later, they explain that actually there was violence in that relationship. Of course, that would, a relationship breakdown or natural relationship breakdown is different from a relationship which is broken down as a result of violence. And that can be really important if, you're looking at areas of relocation or the type of accommodation that somebody would need. But it might not necessarily be something that a victim of domestic violence would be comfortable disclosing to someone they've just met, albeit from a local authority. So there is an obligation on local authorities there under the code to ensure that their staff are properly trained and able to deal with this cohort of applicants. And so if you find that information hasn't been disclosed, I think, again, do go back and look at, has that interview taken place with an appropriately qualified staff member? So let's go on to the next page. So these are the three things that an assessment needs to cover. I think we're all probably used to it, used to looking at this by now. The main thing I wanted to say about these three really are, if you look at the middle, the housing needs, again, that does look at all relevant needs, and of course it may be a local authority doesn't think a need is relevant, but I would still push to make sure that when they are doing assessments, that everything an applicant wants to be included in there in terms of needs is in some way reflected, even if the local authority don't agree. It's really important to have that in there and to make the local authority explain why they think that is not a relevant need, because the starting point is that all relevant needs, whether the local authority thinks that they can be met in certain ways or not, or whether they think they have an obligation to meet them with somebody else, that doesn't matter as far as I can tell. It should be in there in any event. Next slide. In terms of the reasonable steps themselves, pretty basic stuff, really, just re-emphasising some of the points that have been made. They've got to be practical, they've got to be reasonable. We shouldn't be seeing these personal housing plans which are the same despite, you know, there's 10 different people coming through the door, and all of them having the same personal housing plan. And they've got to be realistic. And realistic has two, well, at least two parts to play here, because first it has to be realistic in terms of the steps that the people can do, rather than making people do steps that they can't do. But also, I think they have to also look at whether they are connected, or whether there is a connection between the steps and what the circumstances are which led to someone being homeless. By that I mean, I have certainly seen reasonable steps where it will just be something like somebody has become homeless as a result of perhaps rent arrears. The reasonable steps are simply that an authority is going to provide them, as I said earlier, with information on landlords and local housing allowance. And then the applicant's steps are to go out and to meet with landlords and to try and find somewhere to live. Well, that isn't realistically going to deal with the circumstances which led to them being homeless. They may have poor credit, they may have poor money management. All of those things have to be taken into account when looking at the steps. So how is an authority going to get over or help the applicant get over the fact that landlords will be less willing to help them? How is an authority going to help an applicant get over the fact they have poor credit? What assurances can an authority do or give to landlords? What relationships do they have with particular landlords that they might be able to sort of rely on? Those are all things I think that you have to sort of push a local authority to answer, rather than it simply be a really basic plan which is effectively doomed to fail. And again, the last point there, 11.32, in terms of keeping under review, as I mentioned earlier, the starting point is that authorities should be establishing timescales for reviewing these plans. And that again suggests that it's not a case where timescales should be triggered, or a review should be triggered by particular events. They should be happening as a matter of course. Next slide. So you get some examples. I won't go through them all. I pulled up this slide just to draw an analogy. You get some examples of reasonable steps in the code itself in chapter 11. If we go on to the next slide, Daniel, you may also get some assistance looking across the Severn into Wales, where this framework sort of originated, the general framework, the prevention framework. And there are also some ideas in there. Now, of course, not all local authorities are going to be able to deploy these sort of resources. But if you are looking at a plan and thinking to yourself, oh, well, actually, what could we suggest that they do in order to deal with this, then do look at the Welsh code as well, because you may find some things which are more tailored to your client's needs. Because I think that's one of the things when Daniel comes on to talk to you about in a little bit more detail. But one of the things I think you have to consider when you are challenging either the assessment or the plan, or the reasonable steps, one of the things that you do have to consider is, what do you say they should be doing differently? Because you have to be able to answer that question. I think it's a relatively weaker point to be saying, well, I don't know what they should do. They should do something. It's much stronger to be able to say, well, actually, this would be a reasonable step, this particular thing, and it would deal with this problem because. You may not be able to do that in all cases, but certainly I think starting from that position is a better one to be in. Next slide. Just very quickly on the relief duty, because again, I think we've all been dealing with this quite a lot in the last few years. The triggers are the same as for section 189A. The duty then, or the sort of primary duty under that, under section 189B, is contained in subsection 2. And again, it's taking reasonable steps to help the applicant to secure a suitable accommodation becomes available for them. Important to note, it is not a duty to simply comply with the personal housing plan. If Parliament wanted to say that, they would say that. That's important because you may find authorities who say, we put our steps out in the plan and your client didn't argue or quibble with the plan. And that's what we've done. And therefore, we have complied with the duty. And that is not supported by the wording of the Act. And as we'll come on to see in a moment, that is also not supported by the wording of the code. All that is said in subsection 189B is that in deciding what steps to take, that they must have regard to the assessment of the case. And that's all. And having regard means that if there are steps or there are matters in the plan which should be taken, which will be done, then yes, they should form part of the reasonable steps. It does not say that it starts and ends at that point. So next slide, please. Just flagging this part of the Act, just to mention really, of course, again, a few different ways that the duty can end. The first one is a sort of a more automatic one, which is effectively where somebody will go on to meet the criteria for the section 193 subsection 2 duty, i.e. the main housing duty. That will happen automatically at the end of the relief duty, in the sense that there's no need for a notification of it. But other than that, it can only end in one of the ways set out in subsection 7, and that has to be given in that has to be notified by a notice as referred to in subsection 5. So if we go on. The main one that we're looking at for these purposes is subsection 7B. Subsection 7A can become relevant effectively where the relief duty or the steps taken in the relief duty have actually worked. So they have resulted in somebody getting accommodation, and a local authority could discharge their duty under section 189B on that basis. The other sections we won't go through, but we've included them in the slide for completeness, but really we're looking at subsections 1 and 2 in this session. So next slide. And we can go on to the next slide again. Just in terms of what the Code of Guidance says, again, reiterating the point made earlier, they must include the steps in the personal housing plan drawn up, nothing to say that they are limited to those steps. And the other point is that the steps should not be dictated by whether the local authority has taken a preliminary view on whether somebody's going to be owed the main housing duty or not. And again, the rationale for that comes back to this being an Act, or these changes being implemented by an Act, which was designed to help those people who would otherwise fall through the cracks. So that is really important, I think, in any challenge, to keep that sort of front and centre. But the fact that somebody is unlikely to be owed the main housing duty is not a reason for a local authority to limit the resources that they deploy to help relieve their homelessness. Next slide. And finally, just on a last few points on the relief duty before Daniel goes on to deal with challenges, just to flag that local authorities can exercise a power to source accommodation themselves for somebody, if that's what they want to do. And the Code of Guidance suggests there are certain groups of people who that would be more appropriate for. And this is important because if there is a power to do it, then that means that has to be exercised lawfully, but by reference to public law principles. So things like disability may, in the public sector equality duty, or the best interest of children, and section 11 of the Children Act 2004, those sort of things, they may come into effect or may become very important when looking at how a local authority is performing the relief duty and any decision that they make not to secure accommodation. And the starting point is going to be that a local authority will say we have no duty under the relief duty to source accommodation ourselves, for your client. And that is right, but there is a power to do it, and therefore if they're asked to consider doing that and there's a good reason for it, and why perhaps the relief duty might otherwise really not be very effective at all or not be very helpful at all, then that then that should be brought to the local authority's attention. So don't forget that provision. And the next slide. There we go. I think Daniel's going to now talk to us about the importance of the assessment, and then we will look at the challenges.
Thank you, Eleri. So as Eleri noted, I'm going to first talk a little bit about why getting the assessment right matters, and then a little bit about how the assessment and the PHP be challenged. So then getting the assessment right. So I just want to make 4 points which really echo some of the points that Larry's already very clearly set out, but I think it's helpful to build upon that as we explore why it matters and as we explore how it can be challenged. The first point is that really Section 189A is like the foundation of the house of the approach to homelessness assistance under the 1996 Act. That's following the 2017 amendment. And a key point there is the low threshold, which Larry pointed out, which is eligibility and being homeless or threatened with homelessness, and that's it. And of course, the idea behind that is that, contrary to the practice that was often seen before the 2017 Act, all people who meet those very low threshold requirements should be provided with assistance, and not just those with priority need. Again, a point that Eleri sets out, but I think has to be kept in mind, is this requirement for a positive and collaborative approach, which of course is explicitly mentioned in the guidance. The assessment should not be a tick box exercise that's just done incidentally while the authority is conducting the Section 184 inquiries, which is something that I very often see, is that there's really an initial intake done by the council pursuant to a homelessness application, and incidental to that meeting, phone call, or what it may be, there's some sort of assessment that takes place. That's not really the idea. And I would say for that reason, it's so important that there's a review of both the assessment and any plan that's agreed, and that there's an agreement where possible about the steps that are taken, because that is a positive and collaborative approach. It's not a tick box exercise approach as to whether or not someone meets a certain requirement, i.e. priority need. And again, as Eleri has already pointed out, really what the assessment is about understanding an applicant's case. What are the circumstances that cause them to become homeless, or in case of the prevention duty, threatened with homelessness? What are their housing needs, and what accommodation is suitable for them, and what support is necessary for them and their household. Now, in my view, the Act really proceeds from the proposition that in order to help a person, you must understand their case. And that broad approach is echoed in the Code of Guidance. And one of the points I think there is the fact that local authorities are minded to be mindful of their duties under the Care Act as well. So not just looking very limitedly at specific issues, but being mindful of those broader issues. So 4 points then. Yes. So 4 concrete examples then of why getting the assessment right matters. So first is suitability. Now, the assessment pursuant to paragraph B of subsection 2 of section 189A explicitly links what accommodation would be suitable for the applicant with the housing needs of the applicant. And I would say that that's a significant change from the traditional approach to suitability, where suitability of specific accommodation which has been offered is either reviewed, appealed, or challenged, where of course the threshold is very high. In contrast here, section 189A2B requires housing authorities to assess at this very early stage what accommodation will be suitable in relation to the housing needs of an applicant. And that's so more in a generic, though individualized sense at an early stage, rather than looking back at when accommodation is being offered or when an accommodation comes up. And I would say that there may be arguments that a failure to comply with that statutory duty under Section 189A prevents a housing authority from lawfully considering suitability of any accommodation that's subsequently offered. So in other words, if accommodation is being offered, let's say pursuant to the main housing duty or interim housing duty, that accommodation must be suitable. And in order to know whether it is suitable, an housing authority must be able to look back at an assessment and say, well, we know from that assessment that these requirements make accommodation suitable or unsuitable. Now, there haven't been any explicit reported cases on this point, although one of the cases I'll mention later on does touch upon it slightly. But if anybody has any of those issues, of course, please free to contact Eleri or me. I would be very interested to assist. And I'm very certain that this will come up more and more in future. The second point is very straightforward, and that's support for the intentionally homeless under Section 190. So if the housing authority finds that an applicant is intentionally homeless, they're still required to assist them under Section 190, and the manner in which they do so is determined, at least in part, by the assessment under Section 189A. And again, that echoes this idea of all persons should be assisted, not just those with priority need and not just those who are unintentionally homeless. And similar to the suitability point, if there is no proper assessment, then the advice that's provided there is arguably going to be deficient in some way because the local authority doesn't know the person's case on who they're advising. The same thing with the personalized housing plan. The assessment is the basis for the personalized housing plan. So after it's been completed, it has been written down and sent to the applicant, and the authority and the applicant must then try to agree to PHP. Now that sequence strongly suggests, and of course the Code of Guidance explicitly requires the PHP to be tailored to the applicant's case as set out in the assessment. And again, unless that assessment is properly done, then the PHP is likely going to be deficient, because how do you know what steps to take to help someone if you don't know the person's case? And all of this, of course, leads up to the final point, which is reasonable steps. And while we're focusing on the relief duty under Section 189B, arguably that also applies to the prevention duty under Section 195, which is reasonable steps. In determining what are reasonable steps, regard must be had under both the relief duty and the prevention duty to the Section 189A assessment. And as Eleri noted already, and I'll just reiterate here, is that in subsection 3 of both 189B and Section 195, so both the prevention and the relief duties, there's a reference to the assessment, not to the PHP, but to the assessment. And so unless there is a proper assessment such that the local authority understands an applicant's case, it at least arguably cannot know what steps are reasonable in the applicant's case. And that's not to say that, as Eleri said already, is that the assessment is a necessary condition. It's not sufficient. Just having done an assessment doesn't mean you are taking reasonable steps, but you must do an assessment in order to take any reasonable steps or know what those steps are. So that then brings me to challenging the assessment and the plan, or the reasonable steps. So as is often the case with homelessness cases, there are really two routes here. There's either the review and appeal route under this 96 Act or the Judicial Review Act. So starting then with the review of reasonable steps for ending the duty. Apologies. The 96 Act only allows for reviews and subsequent appeals of first the steps a local housing authority are to take pursuant to the relief duty, or in this case also the relief duty, and the decision to give notice to bring those duties to an end, as Eleri said, 7B. So it's important to keep in mind there's no statutory right to request a Section 189A assessment, nor of the personalized housing plan explicitly. And so there's basically two approaches that one can take to that scenario. First, that any failures under those provisions, so under Section 189A, can only be challenged by judicial review, subject to the usual constraints. And I'll get to that in a moment. And second, you can argue that the compliance with Section 189A, so that is to have a proper assessment and then to agree a proper personalized housing plan in the way that Larry set out earlier, are conditions precedent for the relief duty. And that means that while failures under Section 189 can and arguably should be challenged by judicial review, those failures prohibit a local authority from complying with the relief duty. So in other words, unless a proper assessment is conducted and kept under review, and a proper personalized housing plan is developed, and in case of any review of the assessment adopted, a local authority cannot know what steps are reasonable. And of course, if a local authority cannot know what steps are reasonable, cannot comply with the relief duty, that is to take reasonable steps, and if it cannot comply with taking the reasonable steps, then it cannot end the duty, because that's required before it can be ended. Now, I've dealt with recently three of these cases, and in two of those cases, the submission of the appellant that the Section 189A requirements are conditions precedent were accepted. So the court agreed. And in the one case where it was rejected, we appealed to the Court of Appeal, but then as we were awaiting the permission decision, the council offered our client the main housing duty, and so the appeal became academic, obviously very helpful for the client, less helpful so for this presentation today. In the two successful cases, and so one was a Section 204 appeal of the review of the ending of the relief duty, so that's the Hackney appeal, case note of which is on was both in LAG and on Nearly Legal's blog. And the other was a 204 appeal of the review of the reasonable steps under the relief duty. That's the first one most of these cases. And like I said, on both those occasions, the court accepted the conditions precedent argument. So in the Hackney case, the assessment basically failed to engage with the appellant's medical problems and the way that those medical problems impacted on his housing and support needs. And as Eleri indicated earlier, it was basically a bog standard, here are some leaflets, go find out where you can find accommodation. This is our relief duty complied with, without any regard to the appellant's medical problems and how those limited his abilities to do that, for example. And in the first, the and Westminster case, the assessment made that mistake, but it also failed to properly identify the circumstances in which the appellant had become homeless in the first place. And that was particularly relevant because their answer, as some of those watching may often experience, the council's answer was, well, you should just get private sector rented accommodation and then all would be fine. But his problems with becoming homeless were very much specifically related to that. And so the circumstances there not having been identified prevented the local authority from providing useful assistance there. And then interestingly, and I do mention this because it may be approached that the court, until we have some guidance, approach that the county court may take was in SC in Westminster. So there the court agreed with the appellant's criticism that the assessment had basically been hopeless, didn't really deal with the requirements, was inadequate. But the court found that unless that failure to comply with the requirements under Section 189A, so that's the circumstances, the housing needs, suitability, and the support needs, unless any failure of the assessment to comply with those requirements was challenged by judicial review, an appellant was prevented from raising it at a later stage. So that particular case was a 202 review and then an appeal 204 appeal of the ending of the relief duty. And that's why I put this little quote there, where it said the judge found that it's not permissible to utilize Section 204 to unwind the whole process. Because effectively, as I said at the beginning, if you view the assessment as the foundation, if you pull that out, then the house collapses. I mean, maybe the house, using house, not the most appropriate metaphor here, but you get the point, I'm sure. And the court didn't like that because it implied that if the housing authority made a mistake at that early stage and it didn't correct it, it could be criticized for that months down the line. Of course, the answer to that is, well, then don't make that mistake in the first place and invest in the proper assessment, rather than putting a duty on homelessness applicants to find a solicitor within the first 3 months of having an assessment and going through the pre-action protocol process and judicially reviewing it. But that is what the judge found in that case. Now, clearly, my view is that approach is wrong. But I think it's important for everybody to be aware that that's arguments that councils are likely to run in response to these challenges, and one that some judges may find appealing for the reasons I've set out. And until the Court of Appeal provides some guidance, that is a risk we should be aware of. So that then leads me to judicial review. And I think what's helpful here is that there's a reported case I've listed here, X and Y and Haringey. Now, I do know from my practice and from Eleri's practice that these cases do happen quite regularly, but they usually settle. And they settle for the second point, and I'll get to that in a moment. So in X and Y, the claimant challenged the council's failure to identify her needs for ground floor accommodation and their need for accommodation near to her parents. And it was held by the High Court that the defendant's assessment was inadequate and unlawful. I think there's 3 key takeaways from at least a relief duty perspective in this case. First, as I hinted at earlier, the failure to identify needs in the assessment does impact on whether accommodation offered is suitable later on. So in this particular instance, there were very good reasons why the claimant needed ground floor accommodation due to disabilities, and good reason why she needed accommodation due to her parents, partly due to childcare, but also due to her disability. And the failure of the council to identify this meant that it was offering her accommodation that wasn't meeting those needs, and therefore she couldn't accept and was unsuitable, and of course a waste of time and resources of all involved. The second point is that subsequent reviews can remedy or rectify failure. So Haringey's assessment in March and May of 2019 were considered inadequate and unlawful. But by July of 2019, they'd rectified it by having a review of the needs, of the review of the assessment, and they adjusted their approach. And so the court found that the claimant was entitled only to her cost up until the July 2019 rectification. And then subsequently, she was awarded half of her cost after that because of an offer that was made. But that points out, obviously, one point that we should keep in mind in these judicial reviews, which is if you draft the pre-action protocol letters properly, it should settle, which is my experience, and I think Eleri's experience as well. Because often it's just a way of pointing out to the council, these are the steps you ought to have taken, you haven't. And if you do that, if you do take them now, then we can move on and start afresh, so to speak. And if local authorities do that, then there may be no need for things to take things further. So I think at this point, oh, sorry, and the third point there listed at the bottom, is there was a finding that the assessment and the agreement or steps did not need to be recorded in one document. Now, I just mentioned that there because it's something that potentially councils may pick up on and raise during a review process or potentially a challenge, and suggest that either the assessment or any agreement somehow is reflected in other documents when viewed holistically. And they would rely on that finding in X and Y. Now, I do wonder whether that conclusion is correct. I certainly would argue against it, especially given that an applicant needs to be notified in writing of an assessment. And so it would appear that notice in writing would have to be in one document. But I just thought I'd set that out there as a sort of caution, as a point. Yeah, so at this point, I think I'm going to hand back to Eleri, who's going to deal with 188.
Thank you very much, Daniel, for that. So yeah, so just a short word really on the interaction between section 188 and 189B. Two issues that we have seen crop up, which I thought would be helpful to perhaps go through. The first thing to remember is it's an obvious point for us, but sadly, in my experience, not quite such an obvious point for local authorities. They are different duties. They have different thresholds, and performing one doesn't necessarily mean you are performing the other. Section 188 is obviously interim, and it is the threshold is lower than a section 189B. It's effectively reason to believe as opposed to being satisfied, but it is wider in the sense that priority need or apparent priority need is included in that. You may find somebody who is not a peer or doesn't have an apparent priority need and therefore won't trigger 188. But the 189 duty is accepted because they are clearly homeless and eligible for assistance, and the local authority is satisfied of that. But then something may happen which puts them in priority need, or they may have been someone who perhaps there was, their circumstances did trigger section 188, but at that time they perhaps didn't need interim accommodation because they were staying with friends or something like that. They didn't want it. But if that then changes, what does a local authority do? The short answer is to treat the duties differently. And the reason that I raise it is because I have seen cases where that exact scenario has happened, where there is a 188 duty and that, so there was always a 188 duty triggered, but perhaps it didn't need to be actioned immediately. And then when that has been raised or circumstances have changed and somebody then does need interim accommodation, that has been treated as something which doing that has meant that they have performed the section 189B duty, which seems completely illogical and confused to me. But nevertheless, we raise it because it has happened. And I think approaches like that need to be challenged straight at the off. They are completely different duties. And putting somebody in section 188 interim accommodation and leaving them there for 56 days, it is simply not sufficient. And the way to go, the way to challenge that is to sort of go back to basics and say, well, look, 189A, That's your assessment. You need to do that assessment. How is providing interim accommodation going to deal with any of those things? The reality is it's not. It's just going to postpone postpone somebody being out on the streets effectively. So that's something I would just sort of be eager to point out. The second thing, just to keep a watch out for, is that somebody could be in Section 188 accommodation, and the relief duty could be being performed, but it doesn't necessarily mean they will stay in Section 188 accommodation for the entirety of that time, or that they would be entitled to. And an example of that might be where a local authority has made a decision before the end of the relief duty, that after that duty ends, they won't be owed a duty under Section 190 or 193. And the reason that they're able to do that, if we go to the next slide, Daniel, the reason we're able to do that is because of how Section 188 now operates. We've put this sort of flow chart, I suppose, in there for you to keep. But if you look at the sort of right-hand side, so this is people where the local authority is not going or doesn't find that they have a priority need. If they make that decision and there is nothing to stop them, although the code suggests that they shouldn't, or they certainly shouldn't be preoccupied with making that decision, it also says that, realistically, if somebody isn't going to be owed the main housing duty, the sooner you tell them about it, the better, to prepare them. But because the way that the duty operates, it enables an authority to make a decision on the main housing duty, to tell somebody that they're not going to be owed a duty. And then if that happens to happen within the 56 days, then there isn't really anything to stop them then from ending the Section 188 duty. Now, I've not seen that happen, but in principle it could. And so I think that's just something to be mindful of when Daniel's seen it happen. There we go. It's something to be mindful of. And obviously, you might want to be challenging failure or refusal to exercise a 1883 or subsection 3 power. But that's, again, just something to be mindful of. Some helpful points made in Mitchell. That was one of the first cases, and in fact I think it is the main case really, where the court looked at how the new Section 188 regime operates. There's slightly, so this chart will deal with most cases, there's slightly different situation where you have someone who's reapproaching the authority, and they are going to fall within Section 195A subsection 1. They're slightly different, so you need to have a think about that if that's the scenario of your client. But most cases it's going to fall within this this flow chart. So just keep an eye out for that in terms of managing clients' expectations. And then the last thing we just wanted to raise, you can move on, Daniel, to delay. So if we go on again, these are the points. So I've seen delay come up quite a few times now, and these are the points that I have seen them, or where they're most likely to come up. The first one, a delay in taking an application. Well, that's sometimes the sort of age-old gatekeeping tactic. Delay in making the initial assessment. Sadly, I've seen a number of cases where people in all different circumstances are simply put into interim accommodation, and they are left there sometimes for months. In fact, I think actually sometimes, well over 6 months, coming up to a year. Delay in giving a PHP, so that might be whether an assessment has been done, but they simply haven't told the client what the steps are. Delay in decision on a relief duty, so again, accepting the doing the initial assessment, but not actually telling the client whether they accept a relief duty at all, which is particularly unusual given that the test for Section 189A and Section 189B are effectively the same. And then a delay in carrying out the steps. So that might be where a local authority has, said we're going to do these X, Y, and Z, and then they just simply don't do them for a significant period of time. One of the consequences of the new regime, of course, is that we do get Section 184 notices earlier in the process because they are there for the initial duties as well as the main duty. But if we go on to the next slide, just a couple of principles from the cases that I've done, which I have found helpful to bring to the authorities' attention. In relation to cases where there's been a delay in taking the application or doing anything, just reminding the authority that that duty is immediate and absolute. The duty to make inquiries, once the criteria appears to be met, or once the criteria is met, they have to do it. They can't simply say, we'll do it in 6 months, or go and try and find something yourself, or even something which I think is a risk now, where local authorities will say, well, here is the information that we would give you, and it might be the same information that they would give somebody in a personal housing plan. Here is the information, you go off and try and do this, and if you're not successful, come back and make a homelessness application, but this is what we would be doing for you anyway, so you might as well just go, don't worry about the fuss of that. Well, that again is not the approach. That is a similar approach to what happened in Raw, albeit of course under the old regime. And you do have to think about with Raw, when you're relying on it, how that interacts with the relief duty, because of course in principle a local authority could, if it was reasonable, if reasonable steps did lead to this, they could find accommodation for somebody, for example, in the private rented sector, and discharge the relief duty that way. And if they did that, then obviously that doesn't lead to a decision on the main housing duty. So it's slightly different, but the principle is there. We know that the court, albeit that it is generally a last resort, we know that from cases like where the court will make orders where it needs to. My own experience, in fact, I think pretty much every time, is that where you can chase a local authority for so long, but they have a number of applicants, and whilst judicial review is generally a last resort and you don't use it where there's other remedies, the reality is that once grounds are served on a local authority, or draft grounds are served on a local authority, you get an assessment pretty quickly after that. That's been my experience, at least. When the grounds are served, it goes to the legal team, and a couple of days later you'll get an agreement to do an assessment, hastily. So I think that's just something to be mindful of when you're looking at whether this is something that you would use the Complaints and Ombudsman Service for, because again they will look at those types of cases, but is this maladministration that can wait, or is this something which actually you really need a remedy from the administrative court now to deal with? And I find that in most cases, when you're at that stage, you probably need something pretty sharpish. Okay, next slide. In terms of dealing with has there actually been any unlawful delay, of course, as always fact specific. Some things that you might want to take into account and raise with the local authority specifically are the effects of delay on any children in the household. So you might have delay which otherwise might not seem unreasonable or unlawful or irrational, is usually the approach that you're looking at. But when you look at the effect of children, of leaving them somewhere without actually moving the application on, that might move it into unlawfulness. And similarly with people with a disability, or somebody who has fled violence, and you may find somebody who has been in permanent accommodation for a very long period of time, and their whole life has been disrupted by sort of violence, whether that's domestic or other violence. Leaving them in limbo is a different scenario to leaving anybody else in limbo, whether it's whether they have priority need or not. So I think that's just something to bear in mind. Unfortunately, we have no longer got clear guidance in the Code of Guidance in England in relation to what period they should be targeting for, and that's because the complexity of the new regime, I imagine. But there are a number of things which I have relied upon in grounds to infer that actually you are really talking about a very short period when you're looking at certainly the assessment and the PHP. If we go to the next slide, and we'll point out some of those points. Why do we infer a shorter period? Well, the first thing is, Parliament through the regulations has specifically put in place a shorter time period for a review of reasonable steps. And one might say that that is really because that needs to be sorted, done and dusted as soon as possible, so that the authority can get on with it, and start trying to relieve this person's homelessness. And that rationale can follow through to the assessment as well. That ultimately this is not something intended to take a very long period of time. You can see that throughout the code of guidance, but realistically, this is a part of the process, getting to the stage of having reasonable steps that you are, that are workable, that are satisfactory. That is specifically been outlined or highlighted, I should say, as a point which needs to be done more quickly than other decisions. There is a caveat to that, unfortunately, which is that if the delay is because of decisions about or inquiries about eligibility or homelessness, and i.e. whether the assessment or relief duty are owed at all, that is still within the 8-week period under the regulation. So local authorities may fall back on that. But in the most cases that I've dealt with, we've been able to argue that as one point. Secondly, the code specifically does say that local authorities need to have arrangements in place for accessible and timely communication. So there is an emphasis on timeliness. Now that is largely in respect of sort of the effectiveness of joint efforts. But as Daniel mentioned, the joint effort starts with the assessment. So there should not be a situation where somebody is put into interim accommodation, for example, or simply that the local authority says, fine, we will assist you, we'll do an assessment, and then it stops there for a long period of time. That is inconsistent with the code. And the final point deriving from the code of guidance that we think is helpful is this idea that local authorities, although they shouldn't allow the inquiries on the full housing duty to detract them from carrying out the relief duty, the code does suggest that really they should be in a position around day 57 to be able to make a decision on the main housing duty. And so if you think that within that 56 days they should have been able to perform the relief duty and make and complete their inquiries on perhaps I would suggest the two more complicated aspects of a homelessness application, which is the priority need and intentionality inquiries, then I think it follows from that, or at least arguably follows from that it should be taking a much shorter period than that to be able to deal with the first two, the eligibility and homelessness. Now that won't always be the case, but I think in most cases that can at least be argued. And I've found it to be relatively successful when I've put it forward, and local authorities have just got on with it. And the final point there in the bottom end of that the code there was, even if it's not sort of a straightforward case, they should still be able to do it some 15 working days later, so about 3 weeks later. Again, you're talking weeks here, not months. And unfortunately, the cases that I've been approached in relation to have been ones where people have been left places for months on end with nothing, and that's clearly against the principles of the Code and the Act. And finally, in terms of just a sort of a last point is, obviously, it's not just about performing the duty, but the duty, certainly in respect of section 189A, includes the notification duty. Local authorities may take the view that actually they do need to get on and do, especially in relation to prevention more than relief, they do need to get on and do the job of preventing homelessness rather than writing up a letter. And there's nothing in principle in the code, and certainly the code supports that they can do that. But I think you do have to keep an eye on that there will be certain steps which have to be taken immediately, but not all steps would have to be taken immediately. So it's about finding that balance and saying, well, you've done the immediate steps. Now tell us what the assessment is. Now tell us what the plan is. And then we can go from there and decide whether that's actually going to be effective. Because again, phoning a landlord and say, can you keep them there for another 2 weeks? That's not going to be enough often by itself. It's just going to push things back, and you don't then want to be 2 weeks down the line still with no idea of what the assessment is or what the local authority plan to do. So I think that brings us to the end of our presentation, just about. Is that the end? Is that the last slide, Daniel?
Yes, it is.
It is, there we go. So that brings us to the end of our presentation. So really it was just about talking through some of the strategies that we have deployed. I can't see any questions, can I? No, none in the Q&A. Hopefully that means that everyone is relatively clear. If you do have any questions, then just let us know. We'll hold on for a couple of minutes. But otherwise, it was nice to sort of remotely see all of you. We can see your names on the side there. If you do have any questions which come later, which you want to ask us, just drop us an email. Our email address is there. You should be able to get hold of us through the clerks in any event. But do let us know. We are in a stage of trial and error very much with these cases, and seeing what's happening. And if these points aren't argued, then they we won't get anywhere with them. So we would encourage people do push the point, do argue them, and then obviously hopefully we will get some guidance from the senior courts at some point. Great.